ready to reconvene the 118th meeting at about 1:25, and we will go to item 6, legal report. Executive Director Day.
Yes, and I know the Deputy Counsel Grossman is right behind me somewhere, so he'll be working his way here.
Here he comes.
But what we have is, we were before the commission just a few weeks ago. We talked about the need for a new qualifier process in the licensing regimen, and essentially that's what we're here for today. We would look, if it's possible, a vote to begin the formal process for these amendments. These are amendments to the regulations, not entirely new. They establish a new qualifier process, the forms, the investigation, and determined by a commission. So it kind of goes through that process just to add them into the process that we have at this point. Besides the formal process authorization, I think we also need to look at the SBIS that may go with it, and ask the commission to consider whether Deputy Counsel Grossman could draft that up and file it, if you could delegate him that authority. Now, with that, I think if you'd like to go through the specifics of the proposed amendments, I'll turn that over to Mr. Grossman.
Thank you. I don't think there's a tremendous amount of areas that need to be necessarily outlined unless there are questions. But ultimately, as Rick said, we've just expanded the existing qualifier section to include new qualifiers. There presently exists requirements for gaming applicants or gaming licensees, as it is, to notify the commission of any prospective new financial sources and new qualifiers, so that remains in place. All this does is it expands the existing language that was put in place for the RFA 1 process and includes post RFA 2 new qualifiers, if you will, so that if there was a new qualifier, just as before, they'd come to the commission refers it to the IEB conducts an investigation. Sections 12 and 16 of Chapter 23K are still in play. Those are the suitability standards. And that ultimately, just as before, if the IEB will develop a report and bring it before the commission, at which point the commission can either elect to pursue a public meeting or an adjudicatory proceeding to decide whether to approve of the new qualifier. We did modify the back end of the process as it pertains to the decision between a public meeting and an adjudicatory hearing, so that there's full discretion. We removed the language that talks about the notice having to come from the applicant as to whether they want a public meeting or an adjudicatory proceeding. There was some thought that process, just the notice part and the 30-day part, added some confusion. So we removed that, and we just say that the commission will decide whether it's going to have a public meeting or an adjudicatory proceeding. Other than that, there's nothing in there I don't think that I'd want to bring to your attention specifically. As far as sections 116 and 101, they were merely just being modified to recognize the expansion to new qualifiers. And I think that's the long and short of this proposal.
So these are where now in the process?
They're brand new, right before you're here for the first
But
time.
they're going out for the normal comment period? Do they
Well,
these
you can-
amendments have to go out for the normal comment period?
They do. Prior to adoption, of course, we have to submit them to the Secretary of the
Yeah.
Commonwealth and the Local Government Advisory Council. So in lieu of offering public comment up front before you start to move it through the process, our recommendation here, as it will be with the slots regs at this point, is to authorize the staff to begin moving these through the promulgation process to a public hearing, which would be in about 5 or 6 weeks from now, depending upon the publication schedule of the Secretary.
Isn't it in that process, there's 21 days, isn't it, of public comment? Or?
Yes, that's right. So there's 2 weeks for submission to the Local Government Advisory Council, and then there's a 21-day period that they have to be submitted to the newspapers and to the Secretary of the Commonwealth prior to the public hearing, at which point we could solicit public comment on our website and otherwise. And just to pick up on the small business impact statement comment, it seems to me that neither of these two, and I'll include the slots recommendation, implicate small business issues that I can think of off the top of my head. So in which case I think it would be relatively easy to draft a small business impact statement outlining what the issues are. If we were to have that authority delegated to us, we could file that along with the appropriate notices, or we could bring it back before you at your next meeting to take a look at.
Mr. Chairman, I might add that you're used to, in many cases, we'll bring a draft before you first. The slots regs have gone through that process and actually have gone through an informal public comment period as well. These are just amendments that we have, and we previously talked about them pretty short and direct. We thought it would be advisable just to move forward with that part of the formal process.
That seems totally reasonable to me.
I see no issue. It's the same process used for a qualifier, other than the one piece which will eliminate confusion, so non-controversial.
Yeah.
Well, I do have one question, and that is with 115.04. We had, under the old provision, we had presumptively you have an adjudicatory hearing on qualifications. But if there was an unqualified, unconditional, the Bureau recommended an unconditional positive determination of suitability, then we could have simply a public hearing. And we did that with a number of RFA1 qualifiers. Now we have it set up so that the commission can use the public hearing process, even if the Bureau does not unconditionally recommend a positive determination of suitability, if the Bureau has not raised any, open quote, complex concerns relative to suitability, close quote, in the report. I don't know what complex concerns means, and what might be complex to the Bureau, not complex to the Bureau or the Commission, might nonetheless raise issues that the qualifier deems important to disprove in an adversary hearing, so in an adjudicatory hearing. So I'm not certain why we are doing that.
Where is the language you just read? Where did that come from?
Page 2 of the, page 316 of the materials, page 2 of the
I got it.
regulations at the bottom. It's
Yeah.
section 115.04. It's the last sentence in 115.041. And then 2 and 3, new 2 and 3 are the
Yep.
adjudicatory proceeding in the public hearing. So I wonder, so I just put a question mark there. I have a suggestion, but first I'd like to find out what the basis for doing this is.
Well, I'm sorry, it is discretionary, right? The commission may, and
Oh, I understand the commission may,
Right.
but under the previous set of regulations, the commission could only use the public hearing process as opposed to the adjudicatory process if the Bureau recommended unconditionally a positive determination.
understood, yep,
And
understood.
that's safeguarded for an adjudicatory hearing, negative findings or negative facts contained in the Bureau's report. It gave the person who was the subject of those negative findings an opportunity to come in and disprove them in an adjudicatory proceeding with examination and cross-examination, which is an important safeguard. I mean, there may be reputational pieces that are here that are not disqualifying, but are tarnishing. So anyway, that's the basis for my question.
I know the first time around we did this, we always used the adjudicatory process when there was an issue that it may not have been disqualifying, but it was an issue that we needed to explore, and maybe have a better understanding of. So people did have that opportunity. So I didn't read this as a way of saying, oh no, let's just use a public hearing process more often, because I didn't see any evidence of that the first time out.
Well, the trigger is complex concerns relative to suitability. I don't know what that is. So, anyway, I've asked a question, and then we keep talking, and so you can't answer it.
The real crux of the issue here was the 30-day notice requirement. That's where we started from when we started looking at this provision. And if memory serves, in each case where the commission held an adjudicatory hearing, it wasn't on the request of the applicant. We, or the commission, decided that there was going to be an adjudicatory proceeding.
Which nixed the 30-day.
Well, that was our argument.
Right.
We got, and in some cases, we got some pushback, mild as it may have been, from some folks that they're entitled to 30 days. And we said, no, you're not. That is only if we don't say there's going to be an adjudicatory hearing, then you have 30 days with which to exercise that option. The bottom line is, as you're pointing out, Commissioner McHugh, I don't think this is a huge issue. This is really just intended to remove that 30-day notice issue. The complex language, I don't disagree. In fact, I guess I'd say I agree, that it may be somewhat imprecise. It was just intended really to give the commission flexibility to decide, and a standard against which to apply it to, when you were going to have a public hearing versus an adjudicatory proceeding. Though it seemed as though in any instance in which there were concerns, you would always have an adjudicatory proceeding. And certainly, if the applicant, if you will, wanted an adjudicatory proceeding, we would always allow that. That was the intention, and perhaps we didn't express that as clearly as we might have.
Well, if the, I mean, two responses. If the 30-day requirement is a problem, then the direct way to deal with that would be to fix the 30 days. But the second thing you said, I would be fine with if we change the trigger to the qualifier's consent, then I wouldn't have any problem with this. So if we took out the last sentence of 115.041 and said the commission may utilize the public hearing process instead of the adjudicatory process with the qualifier's consent, then that would safeguard the qualifier's rights to contest stains that were not necessarily disqualifying. So,
Where is the applicant's right to ask for an adjudicatory hearing now?
there isn't one.
There isn't one. Why did we eliminate that? So you just,
The way this is set up now is that the commission decides whether there's going to be an adjudicatory hearing or a public hearing. Before, there was, the presumption was...
it's only a public, okay. So it's presumed to be an adjudicatory hearing
Correct.
unless the commission and the agree. Okay, sorry, got it. So the commission what you're saying is, whether you need to say this literally or not, the commission may only utilize the public hearing process if the plaintiff, the applicant agrees, or the qualifier agrees.
Yes.
Okay. Okay, I get that. I'm not sure that you shouldn't add the word only in that case, though, because I'm not sure it says that without the word only. I got it, okay.
Does that,
Yes.
does that make sense? Is that-
Absolutely.
Yeah,
Yeah.
okay.
No, that's a good,
And this applies only to qualifiers. Needless to
Well,
say.
and new
New
applicants too,
qualifiers.
for Regency. This
Right.
would apply to Regency.
Right.
okay, great.
Yeah, I think these are good changes.
Okay, Mr. Glennon.
We need a
I think you
motion.
need a vote.
Oh,
to move that forward.
Yeah.
Commissioner McHugh?
I move that with the modification to 115.041, just described, that the commission approve the regulations, the new qualifier amendments to the regulations, and approve them for a submission to the formal adoption process, including the public comment proceedings.
Second.
Any further
Commissioner McHugh,
discussion?
may I ask a question?
Sure.
Would you also consider allowing us to submit the small business impact for this section?
Yes, and so, and to authorize the staff to submit the requisite small business impact report.
Thank you, sir.
Second that as well?
I'll second that as well.
All right. Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. All right. Mr. CIO.
All right, thank you, Mr. Chairman. So happy to be appearing before you before 4 o'clock in the afternoon. On March 6th, we appeared before you and presented a first draft of regulations relative to electronic gaming devices and electronic gaming equipment, approval of slot machines, electronic gaming equipment and testing laboratories, and the possession and transportation of slot machines. In the intervening weeks, we have continued collaborative discussions about the initial draft with our first licensee, Penn National Gaming, commission industry consultants, electronic gaming device manufacturers, including Bally and IGT, independent testing laboratories, GLI and BMM, and regulators in other similar jurisdictions. We've also received written feedback from the Association of Gaming Equipment Manufacturers, or AGEM. On April 17th, we submitted for your consideration a second draft and posted it to our website for informal comments. Today, we bring forward that second draft for a policy discussion. This version includes substantive changes from the first iteration based on our own internal review and the input from the various industry segments I just mentioned. I very much appreciate and want to acknowledge the support that I have received from Staff Attorney Artem Stetnoff, Deputy General Counsel Todd Grossman, and Commissioner McHugh in refining the second draft before you here today. And at this point, I'm going to turn over the discussion to Attorney Stetnoff, who will take us through the policy issues that are highlighted in the draft that the Commission may want to discuss or weigh in on. Artem?
Thank you, John. Commissioners, before you, you have the latest draft of the gaming device regulations, as well as a redline version of those regulations that specifies the value changes that we made since the prior draft that we presented. I would like to go over a few of the important areas in here that are highlighted. I'm going to go pretty quickly, so if there's anything that Commission would like to discuss, we can go into more detail in those areas. On the first page, I highlighted the 80%, which is the minimum return to player that we're going to require. We used to have it at 85%, but after discussions with other parties, determined that 80% might be a better it might be a better floor in order to not prevent some traditional games from being played.
Todd, and I
Was
think
that-
we also, oh, sorry.
Did you say 80? It used to be 85?
It used to be 85. This
Here
is
it says-
a basement.
Here it says replacing 75 with,
In our prior recommendation, it was
The
85%.
number 80 was 85.
oh, I see, okay, okay,
We're changing
In
the
first
standard.
draft, Yeah,
Yeah.
we're reducing.
right.
And the basis for that?
It's in order to not restrict some of the more traditional games that do have a return to player on some of the hands that are below 85%.
So these would, the requirement would, while beneficial to the player seemingly, would eliminate certain games effectively
Yes.
because of the different odds and the different.
Okay.
Makes sense.
So on the following page, paragraph 3 goes into how we're going to define a slot machine that has multiple gaming positions, whether or not we want to define that machine as a single slot machine or as one slot machine per each position. And this has an effect on the Category 2 applicants who are limited by the 1250 limitation on the amount of slot machines they can possess.
Okay,
Yep.
so this deals with the situation in which you have a single unit, but 5 chairs, say, around that unit. It's mostly going to show up in electronic table games, isn't it?
Yes.
Yeah, and that's what the picture at the end is designed to show.
Do we have a picture?
I mean, at the end of the presentation, there's a picture of an electronic.
One more
blackjack
page,
game.
Darian.
There it is, there. Right.
So I took this at Twin Rivers, it's just an example of an electronic table game, does not have any dealer human intervention, it's a 6-position device, and for the purposes of defining slot machine, we're considering each player position to be a slot machine. So in the case of this, for discussion purposes, so in the case of this device, 6 positions, 6 cash in, cash out, it counts as 6 slot machines.
And how is that dealt with in other jurisdictions? I had a question whether that was a slot machine at all, but I take it under our definition it clearly is, because there's no human intervention in the process.
I think those are the 2 criteria which we used. One, there's no human intervention. You can see the dealer is an avatar or whatever.
Right.
The fact that just to define the metric, a player position was going to be a slot machine. And I think in talking with Artem, and Penn's application called out both that they would have 1,250 slot machines and 1,250 player positions. So it made...
So this is compatible with their application?
It is, indeed.
Oh, okay.
Yeah, so, I mean, but it's also an interpretation, right? You need a metric. Slot machine is the only thing that's mentioned in our enabling legislation, and we also have a slot machine limit for the Category 2, so we had to find a way of accounting for that machine. It's obviously up to the commission to make a determination, and I know I've had some conversations with Commissioner Zuniga about, the revenue, if we were to interpret it differently, would be different, so.
Yeah, we have a $600 tax, annual tax on a slot machine, so that device would have a $3,000 annual tax on it under this
Well,
regulation, right?
yeah, but
all the
the
seats
most significant revenue that I'm thinking about is the 49% that comes for each one of the seats, let alone the machine.
So if you interpreted this as 1,
Yeah,
that would give the opportunity to Penn to put in
6
more than 1,250 player positions.
But how would it affect the 49%? The money's
More.
There's more.
There's more money at 5 positions than 1.
one.
There's 5 players as opposed to 1.
It's 49% of gross gaming revenues for the place, not for each machine.
You would
Right.
effectively have more machines.
But if you have 1,600 machines instead of 1,250, because a bunch of them have 5 seats.
No, but that's just definitional. The money is still the same.
No,
This is
Not if you don't permit them. If you count this as 1,
yeah,
then the 1,250 machines is going to give you 1,400, some larger number of positions and of individuals sitting there putting in their quarters.
yeah, but the quarters are still going to be, you're still going to have
The
the
quarters
same
are
amount
the
of
same,
quarters.
but you don't have as many gaming
I
positions.
know,
You
but
don't
you're
have seats.
taxing gross gaming revenues, not machines, except for the annual tax where you're taxing machines at $600 a pop. But the 49% is on gross gaming revenues, whether you have 500 machines by definition or 2,500 machines by definition. The money,
yeah, no, but there will be more money the more positions that you have.
More people are putting in
More
money.
people are putting in money.
The more
So,
bottoms in chairs.
no, I understand that. And this is a very interesting but probably entirely irrelevant discussion. If you
That
have, if you
machine,
have,
let's say, that machine
Right.
will produce the same amount of gross gaming revenue, whether it's counted as 1 or 5.
that's right.
The
No.
machine Yeah,
Yes.
the machine will produce the same amount of gross gaming revenue as whether it's counted as 1 or 5.
Right.
But the building will produce more gaming revenue if it's gross gaming revenue, if it's considered 1.
Yes.
Okay. Okay, I got it.
You're right about the machine. The machine
Right.
doesn't change gross
Right.
gaming revenue,
Right. Right.
but the
I-
building does.
okay.
Yeah.
Light dawns in Marblehead. Got it.
I think, yes, I've had some of those discussions, and there's a real revenue differential here
Got it.
between the applicants. And we are in a uniquely, there's also the difference between the categories because of the tax rate. If the commission is ever interested, and I'm going to suggest that we are, in giving the applicant some leeway as to the mix on these seats versus machine, clearly we would want that on the category 2. Because the Commonwealth collects 49% of any additional dollar there. Now, on the flip side, there was a real intent of capping by the legislature, but of capping the activity, let's just put it that way, for the slots license. So I think when we talk about hypotheticals, I would like some leeway, but not such that results in 2,000 positions. That would clearly not be the intention.
But you'd be okay with 1,257, but not 2,000?
Right, to some percentage. Now here's there's a
So
calculation.
Are you proposing a change to 3?
Yes.
Yes, that we at least discuss a change or some leeway for the operator. The economics are there's not a straight formula as I can interpret it. There's different cost of some of these machines. There's different economics. For example, you highlighted a blackjack type table, but there's a lot of popularity with poker, for example, and for the house, in which case we are. There's not a lot of profitability in poker because that's just not the way the economics work out. The house takes a commission of a lot of what's wagered. But I think allowing some flexibility with some limit could provide the operator a little bit more leeway in the mix that they're able to offer. But you did ask, Commissioner, what happens in other jurisdictions, and their statutes are different. I'm familiar with Maryland. They count up to 6, I think. They have a maximum of a multiple of 6 in terms of relation per machine, 6 seats per machine. There's actually machines that could seat more than 6, but they drew the line at 6. But the economics there are different. They actually own the machines and lease them to the operator, if I'm not mistaken, for which they get the bulk of the economic benefit. And there's no restriction there on how many machines the operator can have.
It seems to me that if, by your definition, the legislature was probably meaning 1,250 seats, and if Penn, who bid it, was thinking it meant 1,250 seats, and our other applicants who are going to be competing with these folks presumed it was 1,250 seats, that we'd be pushing the envelope pretty hard to make it more than 1,250 seats. I mean, and if it was genuinely an issue, if Penn came in and said, here's our proposal, and we're assuming that it permits multiple seats at each machine, then that would be one thing. But But it sounds like your sense is that there's and the facts are that there's a pretty uniform conviction that one means one. And it would be pretty much us making up whole cloth if we make one means 1.5.
I don't fully agree, but I don't fully disagree either. I think from some of the comments we had from other applicants, there was something when they applied for these, that was something we were able to glean, that this was potentially a really beneficial flexibility. I would also argue that there's a real time differential here that I'm mostly thinking about, which is a time period in which there are no table games in the Commonwealth, live table games, because the Category 1s take time to come online. So there could very well be a benefit to us and the operator, and no complaints from the other licensees during a period in which the other categories are not online. So I've even thought and brought this up with Todd and John, whether we could craft something relative to a timing exception. Now, we have a waiver process for our regulations altogether, so we could always find ourselves, if Penn decided that this was worthwhile, to have a request for a waiver on our regulations at any point. Maybe they don't.
Yeah, no, I think that's an interesting idea. What about considering between now and the time the first Category 1 license holder opens, that we would permit a different interpretation. And the motivation would be to maximize the revenues,
Right.
and to some limited extent the jobs to the Commonwealth, and not doing damage to the competitive environment with our Category 1 applicants.
Right.
I think that's an interesting idea.
Isn't it difficult, though, to provide a benefit and then take it away? I think that's difficult at best.
The benefit being the revenue?
Right now, as long as there's no one else open, you can do X, but as soon as someone comes online, it's gone. You can't do it anymore. That's hard to do.
I would
We
bet
could let
they
them-
would prefer it.
Yes.
My guess is they would be in favor
Well,
of this.
they would have to make an economic calculation. Do I buy, lease, or commit to something like this only for 2 years? Well, if it's worthwhile, they might. If it's not, they might not. I think there's an argument that we could make relative to specifically electronic table games. We could see them as in direct competition, even though I'm told they're not fully in direct competition with live table games. That the people who patronize table games prefer the livelihood. But on the flip side, there's also many patrons prefer electronic table games as a way to learn and get comfortable with the games before they try live table games. So.
They prefer the avatar.
For some period of time, until they get comfortable with the speed and company of other players.
Okay, that's interesting.
I would say
I have difficulty changing a definition because of competition, i.e., it's a single machine now, or it's a single machine now, but as soon as there's competition, it's 5 machines.
I'd say it's the other way around. We'd say it's a single machine forever, but we waive the constraint until another licensee opens.
Well, that's a way of disguising what we're doing, but yes, I have difficulty with that, and the contribution to our operating revenues changes potentially dramatically with that with that change,
Right.
right? So,
Well, not necessarily.
Yes.
Well, no, only if Penn National decided to act on it. If they decided it was in their economic interest to act on that waiver,
right.
yes, you would be right.
And then during the interim between now and the time that the casino's opened, the casino's share of our operating revenues would be lower than it would be when the casino's opened.
I'm not sure I
Well,
follow that.
We haven't,
Because our operating revenues, the assessment is per gaming position. And a gaming position is defined as a seat or standing position at a game. So the statutory definition of gaming position would have that machine have 5 gaming positions, however else we
well,
work.
let's assume that what you're saying is right, so go ahead.
I do assume that.
Yeah. I'll grant you that for at least a paragraph.
The statute is not definite
Oh, yes, it is.
We can work.
on position versus machine. There's maybe we should dig up that.
Sorry, I'm reading the statute.
All right,
It
can
says
you-
a gaming position. Gaming position, quote, a designated seat or standing position where a patron of a gaming establishment can play a game.
Okay.
That sounds pretty clear to me.
Yes. What is can we go to
And
the
then-
1250 cap for the category 2?
Right.
What is that 1250 cap on?
Oh, it's,
Is it gaming positions or something else?
Slot machine.
I think it's machine. I think
Yes.
that's true.
That's right.
Right.
Hence the ambiguity.
No, because, not the ambiguity in the contribution to our operating revenues, because it says the contribution shall be assessed annually on gaming licensees under this chapter in proportion to the number of gaming positions.
But
Yes.
so
That's not the one I'm worried about.
right. So yes, that's right. Okay, so we're going
Right.
to change the number of gaming positions.
Right.
That would mean that yes, if Penn National decided to accept this waiver, they'd be paying a larger share of whatever. So what?
Well, I don't know.
I mean, they don't
just-
have to do it. They can
Right.
go, if
Right.
the arithmetic works for
Right.
them,
Right.
that 1250 seats is the way they want to go, that's up to them. But it does seem to me that, the Racehorse Development Fund would benefit from it substantially.
49.
The Commonwealth might very well.
That's it.
We've had our consultants, this is beyond my education level. I mean, I would want comment on this from our other applicants
Yeah,
and from Penn National.
I hear you.
But I think it's a really interesting
Yeah,
idea.
I would want comment too, because it would seem to me the only decision can't be the dollars. Is there something we're missing here? The only reason we change this is because it would be an economic advantage. And I just
Well-
wonder if that's the only consideration here.
Maybe it is.
Maybe it is, I don't know.
I'd like to get some more
Yeah.
comment.
Okay.
I think it's a really interesting idea, and I think we should ask folks like these and Penn National to give us their thoughts. So let's leave this one open. Good thing we didn't take that lunch break, right?
Well, good conversation. It's good
Right.
conversation. Yeah,
Right.
we knew this one would happen.
The next paragraph,
Could you
paragraph
try to pick it up a little bit, Artem? This is taking it too long.
The next paragraph, paragraph 4 on page 324, that tries to solve a potential problem that we may have if we do collect a large amount of data from every slot machine. In the highlighted section, we try to say that we are going to be reviewing the data to some extent, but we're not obligated to continuously review it and make sure there's no problems in it whatsoever, just to avoid any potential liability. On the next page, the highlighted portion, we removed the restriction on cash and coins. So So now, as written, a slot machine can accept cash and coins, but we're still restricting the debit cards and credit cards that are accepted directly at the machine.
I'm sorry, what was that section, Gordon?
Section 143.04, paragraph 2.
Page 3.
What is the page? I'm told.
325? Or 326, I'm sorry.
Thank you.
Which page are you on?
That was page 3, you just
Page
talked
3?
about the debit and credit cards.
Is that, what's other jurisdictions, what's the mix from other places? Do we know?
So I believe that most machines don't, most slot machines don't accept a credit card or
Correct.
a debit card at this point.
That's-
It's, yeah, so this was the section that had the bill acceptor language in which we took out. So,
Okay.
I think,
But they do accept bill acceptors.
Usually, the most common would be
That's it.
bill acceptors and/or tickets,
Yep,
but not direct debit cards or credit cards.
understood.
yeah. The other concern was EBT cards. We wanted to
Yep.
make sure that no, cards that are issued with benefit program dollars on them are used in the facilities.
Yep.
Okay.
So jumping 2 pages ahead to section 143.16, the first paragraph. This specifies that we're going to require the G2S protocol in all gaming devices that are implemented after January 1st, 2017. Before January 1st, 2017, we will accept any device as long as it meets the requirements that we have listed out here. And these requirements are just to allow us to monitor those devices and properly regulate the gaming establishment.
How is this a change? I'm trying to remember.
Before, we had a specific requirement to only accept a G2S protocol version 2.1, and we received comment that that may be too restrictive, as a protocol changes often, and it would prevent prior protocols from being used, even if they were equally
I see.
equally good for our purposes. And also, before, we didn't have a grandfathering in of devices that were implemented before January 1st, 2017. That was a cutoff date after which all devices currently in use have to be G2S. Now, any device prior to January 1st, 2017 can still continue to be used.
And that was an accommodation in our discussions with Penn so that they wouldn't have restrictions putting in devices.
What about the Category 1 applicants? Would they, I mean, these days clearly would benefit Penn, but if the Category 1 applicants take a while to construct and get some of these approved, does that effectively mean that those applicants would be
I
effectively
think the
required?
build-out of those facilities is far enough in the future that we're expecting that they would, bring in and deploy only games that provided the G2S protocol.
G2S protocol.
Yes.
Now, I know you've actually explained this twice, so I'm going to ask for a third time.
Yeah.
But summarize the G2S protocol evolution, if you will, and what this does to certain manufacturers versus others.
So the traditional protocol is called the slot accounting system. It's the protocol for all legacy machines. The 150,000 in Las Vegas all give off slot accounting system SAS data. It's older, and the ability to connect and manage these slot machines using software is much enhanced with G2S. It's back in 2006, the Gaming Standards Association started the process of working with manufacturers to come up with a common set of protocols that could be implemented across the industry, and that's what this is. So it basically helps manage the endpoint machines, know what software is on them, be able to get information in real time about the status of the machines. Now, there are conversions. SAS it can be made to look like G2S, and there are accommodations because the industry is in transition. And I think we've taken that into consideration by giving a period of time. But I think for our purposes, collecting the data that comes out of these endpoint devices is going to give us the ability to regulate, I'm going to say better. It's going to give us an enhanced ability to understand what is happening at each of these devices, and also to work with the operators to better manage them. So I think the richer set of data that comes out of G2S is what we're looking for. And I think there are issues because retrofitting some of the lower tier manufacturers don't have the wherewithal to be able to do this engineering. And so I think that's the reason that AGEM has objected on their behalf. They may not, in their roadmaps, have a movement towards a standard, but I think the standard is important, so that's the reason we put it in, and that's kind of the history. Did that answer your question,
It does very well.
Okay. All right.
And it's the smaller manufacturers that, have the disadvantage, if you will, because their evolution to the G2S protocol is perhaps lagging compared to the bigger manufacturers.
Even the top tier manufacturers have been slow to go to the standard because a lot of their intellectual property is in proprietary processing, right? So I think IGT is the most adopted, and then as you go on down the line, others in the top 5 to 10 are moving this way. But it's been slow. Again, they started in 2006, and it's still still ongoing.
Right. I mean, and we could always modify any of these between now and 2017, but we're not worried that before then, that this would give a particular advantage to very few entities that manufacture.
I hope it would not.
Right.
Yeah.
Okay.
So going forward now to page 334 of the packet. The next highlighted section is paragraph 3 on that page. So when the independent testing lab issues a report to us, laying out the testing that they conducted and all the internal operations of the device, that report may not necessarily remain confidential under the public records laws. So we'll need to figure out a way to ensure that we get sufficient information from the testing lab, as well as be able to keep the internal operations confidential to not harm the to not harm the gaming device vendor.
How does the gaming device's integrity is harmed potentially?
Because some of the gaming devices contain like trade secrets in terms of what kind of payouts to give at what times, what the probabilities are, and if that kind of information went public, it would be very difficult for us to attract gaming vendors to sell their machines in Massachusetts.
Fair enough.
Okay.
Thank you.
The next highlighted paragraph, paragraph 5, is the question of reciprocity and when we're going to accept the testing conducted by another party or in a different jurisdiction for purposes of permitting a gaming device in Massachusetts. As currently written, if an independent testing lab conducts a test in Massachusetts, then any other independent testing lab in Massachusetts can rely on the results of that test. Also, we allow reliance on the independent testing lab's results that are conducted outside of Massachusetts, as long as it certifies that the results are reliable. And finally, we have a provision here that says if a device is in use in another jurisdiction for at least 6 months and has performed in conformance with the data, then that device can also be used in Massachusetts without additional testing above that.
And that's a common practice, right?
It is.
Not-
Right.
we do the same thing for background checks?
We just contradicted each other there.
They're working
Yes.
on it.
So the common practice is to allow the independent testing lab to rely on testing conducted by another lab in the same state.
Right.
And some jurisdictions also have a list of approved jurisdictions that they want to allow reliance on.
Right.
But we have had some pushback on any devices that were operating in a different jurisdiction for 6 months, because even though they may have been operating there and they may have been operating perfectly fine and nothing went wrong first, that might not give us sufficient data to make a determination. And also, they may have been operating under certain conditions of which we are not aware when permitting the device.
So who's giving us the pushback on it?
When you say pushback.
It wasn't really pushback, they were just pointing out a potential problem with this
Yeah.
approach.
So I think we're trying to allow for sharing of data and not being redundant and not having to retest.
Right,
It's
absolutely.
very unlikely, given the relationship that the two major players in this space have, that there's going to be a lot of sharing or dependence on each other's results. I think we're trying to provide for it here. So I think we're being more open to the process. My guess is that this will not be taken advantage of, and that based on feedback we've had from the labs, they would be reluctant to use a competitor's results as a part of their certification to operate in this jurisdiction.
Right, okay.
So on the following page, we get into the fees associated with permitting. Currently, we have set a $500 application fee for the permit, and then we're going to assess the remainder of our costs onto the gaming vendor. For the certification process, to certify an independent testing lab to conduct testing on our behalf, we set an initial application fee for that certification at $5,000 so that we can conduct the necessary background investigations in addition to testing, in addition to determining whether or not the lab is qualified. And if any fees go over, we're going to bill it back to the independent testing lab as well.
When we talk about, I'm looking at the $500 figure here, and for permitting a gaming device, if an applicant wants, so is that a physical device?
No,
Each one?
so the permitting is for the software image which is being tested, or the configuration, so to speak. It would be, what are we testing on the platform, and the permitting would be for the instance, and then they could bring in and register as many devices that use that instance as they wanted at no cost. The registration would be asset management. The permitting would be the $500 fee for permitting and testing that configuration of software to run on the platform.
Right. But every time we test or retest, the permit fee applies.
It does,
Yep.
yes.
Yep.
Yeah. A change like that, that's kind of a baseline, because depending upon the complexity of the test, there may be
more.
more or less effort required. Yeah.
And these numbers change from the last draft?
No, they're the same.
Okay.
We did implement the $5,000 application fee for the independent testing lab certification, though.
Does the issue of the commission having the wherewithal to determine public hearing and adjudicatory proceeding, Commissioner McHugh, does that cause you concern?
I believe the same language you discussed earlier is in our regs, and I think we'll just have to come to the same resolution. Todd, is that?
So you would make it the same standards for adjudicatory versus, so the presumption is adjudicatory unless we get the consent of the applicant?
I think we were going to say if there was no problems, we'd do a public hearing. If there was problems that, or however you changed it.
Well, that's
The
what we
idea
changed.
was to make it easy and
We
not have
changed
to be a full
so it
adjudicatory
would be-
proceeding if there was a clear suitability or to certify.
It should be the same, right?
So so we'll make that the same.
Yes, we'll make it the same.
So additionally to the initial $5,000 application fee for independent testing labs, we have an annual renewal fee of $2,000. This is just to cover any expenses that we incur over the year to make sure that the lab is in compliance. And I believe that is all that we had, unless there's any additional questions.
So at this point, we would ask for you to vote this to move it along in the formal process that Todd described earlier. We, do have some letters and comment, which will include in the consideration of whatever else comes in during that period, but we'd appreciate your consideration.
And I talked to you about it briefly before, John, but so we have, for the moment, deferred regulations that say applied to slot standards that had to do with the responsible gaming features until such time we have the responsible gaming framework really established?
Yeah, so we had initially put in some placeholders to have that discussion, but in discussions with the director, with Mark, we agreed that he will bring forward his responsible gaming framework and any technological implications, if there's something we need to build into our technical standards and regulations, that we'll do so at that time.
Great. Thank you.
Okay, terrific. I think,
We need a motion.
to go forward?
Same motion as we had before, to move to approve the draft regulations with the amendments we just described, approve them for commencement of the formal approval process, including sending the letters to the small business
Impact
Impact.
statement.
statement.
Second.
Further discussion?
And with specific request for comment relative to the section that the count of
Yeah.
the gaming.
We should go, yeah, that's a good, not necessarily.
Highlight that.
Highlight that. We do want to make sure that we get the request out.
Right.
I'm sure people are watching, but that's important.
Is the small business impact statement any different because we're talking about fees?
I think it depends who you're assessing the fee upon. Here, I don't think anyone involved in the manufacture of slot machines really would qualify as a small business. So I don't think there'd be much of an impact.
I think the testing laboratories are also big enough that they wouldn't be considered small business.
Okay. Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
That's another significant step forward. These are complicated regulations.
I'm incredibly
Thank-
impressed, both.
thank you very much.
Both of you guys, that you've learned so much about this stuff so quickly. Both.
I know.
Yeah, both are.
I know.
As we say in Massachusetts, wicked smart.
Yeah. All right, I think
Thank you very
that's-
much.
Thank you.
Thank you. That is everything on our agenda. I think we are ready for a motion to adjourn.
So moved.
All in favor? Aye. And we will reconvene tomorrow at 10:30, same place, same time. Thank you.
All right.